All right, now we're ready to proceed to court. We know what the law is. It's our bundles of rights with corresponding duties. We know where to find the law. We're going to look at our federal or state constitutions. We're going to look at federal or state statutes. If we don't find anything there, we've got federal or state regulations that we can look at. We can look at our contract that's between the parties, uniform state laws, case law, common law, and treaties and executive orders. Those are all the places where we might find that we have received a substantive right or that someone else owes us a duty. So once we have located our law, one of the things we're going to do is go to trial. Or what a lot of plaintiffs' attorneys like to do is they're going to threaten to go to trial, but they really want you to settle. We'll talk about that. So now we're looking at the court system and dispute resolution. What are we going to learn? Well, the first thing we're going to talk about is the system of courts in our country. Then we're going to talk about how our case proceeds through trial. And then we're going to learn what are the alternatives to going to trial. Maybe you don't want to litigate and you'd like to get things done much more quickly. This is a graphic that I'm sure everyone is familiar with, so I'm not going to talk too much about this. This is also in your book. This schematic shows you our parallel systems. We've got our federal court and our state court, all which theoretically lead to the Supreme Court. I say theoretically because, as we're going to discuss in a second, there is no absolute right to have your case heard by the U.S. Supreme Court. One of the things I'd like you to notice when you're looking at the parallel system, both federal and state court have an entry-level court. In the federal system, it's the district court. In your state, it can vary the name. Then there's an intermediary court of appeals. But there's a difference in the state system because almost all states have a third level of court or a second level of appeals, which they often refer to as their Supreme Court. So let's talk about jurisdiction. You read a lot about jurisdiction in the chapter, and it may have been a little confusing. So let's just talk about this quickly. Jurisdiction refers to the power of a court to hear cases. It's the body of cases that that court has the authority to decide upon. I'm going to give you an analogy. With professors, depending upon our training, we have the authority to teach certain areas. I teach law classes because I'm a licensed attorney. I've gone to law school. I've practiced in the areas that I am teaching you. I have no authority and no training to teach accounting. That would not be my area. That would not be my jurisdiction because I have no authority or knowledge or experience to teach accounting courses. My jurisdiction would be law classes. Similarly with courts, when courts are created, and the Supreme Court was created via Article 3 of the U.S. Constitution, when courts are created, they're given authority to hear certain types of cases. The federal court system has a subject matter jurisdiction, which is very narrow, and then state courts have their own jurisdiction. So this just generally what kind of cases they can hear is their subject matter jurisdiction. Appellate jurisdiction and original jurisdiction refer to what point on the court ladder that litigants are on. If you are in a court of original jurisdiction, that means your case is in the first level or first rung of the court system that you are in. If you are in a court of appellate jurisdiction, then that court is empowered only to hear cases that have been tried at lower courts. One party has lost, and they are now on appeal to be heard by the higher level of court. Limited jurisdiction or special jurisdiction refers to courts that only have authority to hear certain narrow types of cases. And you can tell what cases they are because it usually is reflected in the name of the court. So let's look at the federal court system. As you read, the federal court system has very particular types of cases that it can hear. And it makes a lot of sense what types of cases they are, right? They are the cases where the United States is a party. So if any individual or corporation or country or state is suing the United States or any division thereof, they have to take that case to the federal court system. And when I say division thereof, I mean, for instance, if you are suing a federal agency or something like that, that would still be considered the United States as a party. And if you were doing so, you would file your complaint as the plaintiff in the federal district court in the area where you are located. Figuring out where specifically you bring a case is a matter of venue, and we're not going to talk about venue in the class. You read a little bit about it in your text, but we're not going to delve into that. So you don't have to worry about figuring that out. Also, cases between citizens of different states that exceed $75,000, that equal or exceed $75,000. Sometimes that is called or referred to as diversity jurisdiction. So if you are citizens of different states and the amount of money at issue is pretty high, $75,000 or more, you can bring the case in a federal court rather than in a state court. One of the most common places you have this to happen is accidents on the interstate. Because when you're traveling on the interstate and you have a car accident, oftentimes there will be, the parties will be citizens of different states. And you might wonder, okay, well, where are we going to bring this lawsuit? If there's a lot of money involved, $75,000 or more, you could bring that suit in a federal district court. The last two categories that go into federal court system are any cases that arise under the Constitution or federal laws. In other words, if you are alleging that someone or some entity is violating a constitutional right, that raises a federal issue, a federal question, jurisdiction, that's what it's sometimes referred to. So you can bring that claim in a federal court. Similarly, if you are alleging that someone is violating some other federal law, i.e. a federal statute or federal regulation, you could bring that claim in a federal court. For instance, let's say Duke Power is nearby and you allege they've been dumping chemicals in the stream that has polluted your water and caused injury to you and your family in violation of a EPA statute. You might be able, provided that the federal regulatory statute gave citizens a right to sue, if there is a right to sue under that statute, then you could sue Duke Power in a federal district court, even though Duke Power is located in North Carolina and you are located in North Carolina. Because if you're suing on a federal statute, that gives you the ability to get your case into federal district court. And that is also the case if you happen to fall into the area of federal crime. Those cases are also prosecuted in federal district court. Now you might wonder for a second, well, is there a reason to want to be in federal court rather than state court? We'll talk about state court jurisdiction in a minute. And typically the reason that people prefer and like to be in federal court is because there is this perceived notion that the federal bench, the judges elected to, well, actually that's the wrong word to use, the judges who are appointed to the federal court may be of higher quality and less biased than judges in state courts, which are elected. So that's why I needed to correct that. Typically, in many states, the judges are elected. And so there is the sense that whenever you have elected officials, even in positions of judgeships, there can be, partisan partisan politics involved, and that people feel who are elected to those positions may feel like that they have to please the people who put them in office. Federal judgeships are appointed. They are appointed, and the judges in the federal bench do not have to run for election. So in theory, that means they should be more neutral. Not everyone agrees with that either, because federal judges, although they are appointed by the administration who is in office at the time. And that means that there can be some politicizing of even the selection of federal judges, because the executive or president in office at the time is going to have a tendency to seek to nominate people to the bench who share their political philosophy or background. So even though typically people like federal courts thinking they're going to be more neutral and less political, that's not always the case. It may not be the case. So that's just more of a political discussion. All right, so that's one of the reasons why you might want to be in federal court. Now let's talk about proceeding through the court. So at the federal district court, and I've put in white what the names are for these courts in North Carolina. In North Carolina, our state is divided into 3 districts: Eastern, Middle, and Western. We are in the Middle District. So we would file our complaint if we had a federal question in federal district court, the Middle District of North Carolina. This court, being the entry point for our complaint, would have original jurisdiction of our claims. So let's assume we're the plaintiff suing Duke for the EPA violations. And the federal district court would have original jurisdiction over our claims. At the trial court level, as the name denotes, you have a judge and you have a jury, because there is a trial. What do I mean by that? That means that the parties are going to put on evidence before a jury, and the jury is considered the trier of fact. They're going to hear the evidence, and they are going to make the decision as to whether the case has been proven. The judge does not decide about evidence, whether or not does not make a decision as to whether or not one side's evidence or witnesses are more believable than the other. What the judge is there for is to decide questions of law. For example, we talked about procedural laws. If a party alleges and claims that one side did not follow the procedural law, that would be a question for the judge, and the judge would make a ruling as to whether or not the procedure was correctly followed. And they might dismiss the case if it was. Evidence. The jury hears the evidence and decides who to believe. But there are procedural laws that govern what evidence can come into a trial. You're going to do a trial later in the class, and you will get to see that you may try to get evidence into trial, and the judge can make a decision whether or not it's admissible or not. That's because that's a question of law. Then whether or not we're going to believe your evidence is a question of fact that the jury decides. Let's say we lose in our suit in federal district court against Duke Power, and you decide to appeal. Where would you go? You would go to the Federal Court of Appeals. We are located in the 4th Circuit of the Court of Appeals. As you read, there are 13 circuits in the United States. So we don't have a Federal Court of Appeals in every state. They cover many states based upon a region, and we are in the 4th Circuit. When you get to the appellate court, that court has only appellate jurisdiction. They only hear cases on appeal. And when you're at the appellate court, here's something crucial. You no longer have a jury. When you're at the appellate court level of federal system or the state court system, you only have judges. You have typically, usually there are 9 judges on the bench, but they sit in panels of 3. So you would go before the Court of Appeals, the Federal Court of Appeals, and you would have a panel of 3 judges. And in this case, your lawyers would just make arguments based on written briefs. Remember that example I gave you earlier about precedent and case law and trying to distinguish your case from prior precedent? Well, this is where this would really come into play. At the appellate level, you're not putting on evidence anymore. You're not convincing a jury of anything. You are trying to convince the judge that there was some mistake made at the lower court level. Typically, the kind of mistakes that you can get a judge to rule on are questions of law. Was the law applied correctly? Was the evidence that was let in done correctly? Did the prior judge make mistakes? It's very difficult to appeal questions of evidence, like was there enough evidence to prove this? Because most courts are going to defer to the jury. Even if they don't agree personally with what the jury decided, as long as there was some evidence to support what the jury decided, courts will generally, appellate courts are going to let that lower case stand. You would have to reach a standard, and this is really difficult in the law, where you would have to convince an appellate court that there was no evidence to support the jury's finding. And that's really hard to prove, that there was nothing. All right. After you receive a ruling at the Court of Appeals, if you lose to Duke again, you might say, well, I'm going all the way to the Supreme Court. And you hear people say that too on television and in movies and things. That's not actually true. You may want to appeal to the United States Supreme Court, but you don't have an absolute right to have that Supreme Court hear your case. You would make a petition, a request. It's called a writ of certiorari, and the Supreme Court doesn't have to say yes. And in most cases, they do not. The Supreme Court only hears a very small number of cases, and they do it in very narrow circumstances. In one scenario in which a Supreme Court would be willing to hear a case is if we've got similar cases happening in different circuits across the nation, and we're getting different decisions at the appellate court level for the same issue. For example, if in our case we sued Duke Power for some violation of EPA regulation, and the Fourth Circuit that we're in, the Fourth Circuit Court of Appeals, ruled in Duke's favor. But when some plaintiff in the Ninth Circuit sues their power company for violating the same regulation with very similar circumstances, if the Ninth Circuit Court of Appeals ruled in favor of the plaintiff in their case, and we got denied, and this is happening, and it was a significant issue, the Supreme Court could say, well, this is an issue that we need to address because it's the same legal issue popping up all over the country, but depending upon where you live, you get a different result. You get different justice depending upon where you reside. And that has happened in our, over the course of history, where you've got different decisions coming out of certain circuits and same issue somewhere else in the country, and you get opposite result. That's the kind of situation where the Supreme Court would be more likely to hear your case, because in that sense, the court would say, we've got a split among the circuits. That's a common phrase, a split among the circuits, and therefore they would be more willing to hear the case because we want justice, at least the perception of justice, to be the same no matter where you live. You shouldn't have different rights depending upon if you live in the Southeast versus the Northwest. Now, those 3 courts at the bottom, bankruptcy, tax, international trade. What do you think those are? I hope everybody thought limited jurisdiction. Yes, special courts, obviously, right? We know that they have limited jurisdiction by their very name. Bankruptcy court, only kind of jurisdiction that court has to hear is bankruptcy cases. The bankruptcy court is empowered to hear cases relating to the federal bankruptcy statutes. Tax court and international trade are the same. And in these instances, the court with original jurisdiction would not be a federal district court. It would be that court of limited jurisdiction. All tax cases are going to start in the tax court. And then if you don't like your result, you can appeal and go to a federal district court and then go to the Circuit Court of Appeals. Alrighty. The State Court of Appeals in North Carolina is referred to as the North Carolina Court of Appeals. This court may have a different name in other states. And then if you lost again, you might want to think about another lawyer, but you also might appeal to the highest state court of appeals in your state. In our state, it's called the Supreme Court of North Carolina, but that's not true in every state. For instance, in New York, what we would call a Supreme Court of North Carolina is not called a Supreme Court. It's called a highest court of appeals, I believe. Now, as we talked about under the federal system, at the appellate level, we have courts of appeals and Supreme Court of Appeals. We only have judges. There's no jury. We have judges making decisions of law. Now, do you have a direct right to go to the Supreme Court of North Carolina? Yes, you do. Unlike the U.S. Supreme Court, every case appealed to the Supreme Court of North Carolina will be decided. Now, it may not be heard, you may not be granted oral argument, but it will be decided. Both the appeals court and the Supreme Court have staff attorneys. Staff attorneys help the judges and prepare opinions for the large number of cases that they have. As you might imagine, given that most of the cases are going to go through state court because they're a narrow sliver of cases that can go to the federal court system, state courts are backed up. Our state courts, it takes a long time to go through them because there's so many cases. Now, at the appeals level, where we have judges sitting in our panels of 3 making decisions, there are staff attorneys there, and then the judges also have law clerks. This is also true in the federal court level. I was a law clerk at the North Carolina Court of Appeals, which means I would, when my judge, I put my in quotations, the judge I clerked for, when he was sitting on a panel for appeals, I would attend the hearings, the oral arguments, and hear the lawyers make their arguments. I would take notes. After the hearing was done, and there might be 3 or 4 cases heard in a day. After the hearing was done, we'd go back to chambers and discuss the cases, because each judge had 2 law clerks. We would discuss the case and our opinions with the judge. Then we would have actually read the briefs of the attorneys before their oral arguments, and then after they argued, we might reread the briefs, and we'd start helping the judge draft their opinions. Now, as it happened, our judge had the law clerks to draft the opinion first. And we would take turns. There were 2 of us. So sometimes I'd have to draft the opinion. Sometimes it'd be my co-clerk. So I would draft the opinion first based upon the law of what the attorneys have argued in their briefs. And I would do additional research to see if I thought that there were cases that they should have thought of and brought in that are pertinent. I'd draft the decision, and then I would give it to the judge, and he would read it and make revisions, and he may or may not agree with what I found, but typically during the meeting that we would have with our judge after the hearing, the clerks would hear from our judge which way he or she wanted us to write the opinion, like what their decision was, and then we wrote the opinion to in line with what they had decided. And you have law clerks at the appellate level in the federal system and the state system. And for those of you who would like to be lawyers, this is a very plum position that when you're coming out of law school that you want to apply for, because when you can get a law clerk position at the state or federal level, it makes you much more attractive when you are trying to get law firm jobs, and you learn how judges think, what they're looking for, and you get to hear lawyers making arguments at the appellate level. So it's a fantastic thing to do and pursue, and I encourage everyone to do so who's interested in going to law school, becoming a lawyer. So at the North Carolina Supreme Court, all cases are decided. The judges may not hear your case, but a judge or a staff attorney is going to write a decision based upon the briefs that are submitted. And so you will have a Supreme Court result. Now, if you don't like the result you get at Supreme Court, you still have the long shot of writ of certiorari to the United States Supreme Court. Again, it's going to have to fall into one of those narrow categories where there's a split among the circuits, or the other category, I don't think I mentioned it, but I started to before. If you are raising a novel issue, novel meaning new, unusual, hasn't been seen, sometimes that can help you get your case before the Supreme Court. If it's something unusual that needs to be decided, that can help, even if no other courts, no other systems, circuits are struggling with it. If it's so unique or urgent, then sometimes that can help you get over the hurdle. So now I want you to look at, again, at the bottom of our picture. Again, we have courts of limited jurisdiction. In the state court system, some of the most common are probate court, juvenile court, and family court. Now, probate court has nothing to do with probation. A lot of times students think that. Probate court is where estates are handled. So when someone dies, the family, the executor or administrator has to register that with the city, the state, and it's run through the probate court. So that's what that is referring to.